and the necessary basis of social order, and shall enjoy the recognition and protection of the state. And more importantly, Article 45(2) provides that every adult has a right to marry a person of the opposite sex on free consent of the parties. Now, when you read Article 27 on equality and freedom from discrimination, this is now the equality clause. It provides that every person is equal before the law and has a right and equal protection and equal benefit of the law. And then there is another important article provides that the state shall not discriminate directly or indirectly against definition in Article 16 of CEDAW is different from the one that is found in 45. So the question is, if a party comes to court and pursues an argument that that article would allow maybe a same-sex marriage because it's a convention that forms part of Kenyan law, what would your view be about it? And would that be then what we started developing about an unenumerated right?
I can answer?
Yes.
Okay. So first of all, let me just add one more in the list I had given. I've just remembered in the course of you inviting me to Article 45, I have remembered that Kenya now acknowledges for a fact that intersex people are entitled to rights.
Yes.
And that's not one of the rights of intersex and transgender. And I thought, even to the extent it is not enumerated, it is a consideration. I'm just concerned at what it says in 19.2, 19.3b, that to the extent that it is not inconsistent with this chapter 4. Now, just on that issue of transgender and intersex, still, I have sometimes wondered whether the Supreme Court should be asked to determine whether the Constitution on its face, looking at it on its face, is wrong. Because at 45(2), I haven't answered your question, I know, but I'm just laying the ground.
Yes.
45(2) says every adult has the right to marry a person of the opposite sex. Now, what happens to the transgender and intersex people in Kenya whose existence we have acknowledged? have they in effect been excluded by the Constitution? And probably more pointedly, and I think now this comes to the question you're asking me, is if two intersex or two transgender people come and say they want to marry, and the courts have determined that they are entitled to rights, are they then to be denied the right to marry using Article 45(2)? And could it be that the drafters of the Constitution then were mistaken in the wording they have used in 2 because they have in effect discriminated? And further still, whether then the Constitution on its face is wrong and discriminatory. Now, to the question you've asked whether what I would do if I had two same-sex individuals seeking permission to get married to each other. To the extent to which there exists that clause 45(2) saying the limit of people who can marry each other of opposite sex, I would say it is not possible. However, Commissioner, it is an issue I've looked at because I had, in my previous life, I had been asked to consider an argument on this. I have sometimes wondered, Commissioners, whether Article 45 can be read to represent two scenarios. The first scenario is that one limited only to paragraph 45(2), being two adults needing to marry, in contradistinction from a situation where the heading of that Article 45 is headed family. And then one says family is the natural and fundamental unit of society. Whether it is possible to deny permission for marriage, but the Constitution inherently acknowledges that you can have a family of same sex. That would be my contention, that for purposes of marriage, probably as a judge, I would say the law is clearly prohibitive. But then I would wonder then whether the law seemingly at clause 40, so the only exclusion is 45(2). 45(1) and 3 and 4 seem to accommodate existence of a family. And so if it is possible to argue that there is a difference between a marriage and a family, then it should be possible also to say that there is almost a permissive extent to which the Constitution.
Garnier Super UV Invisible Serum. Invisible texture. So lightweight. By Garnier, naturally.
As a legal argument. The second limb of your question was whether then you could say that Article 16 of the Convention on Women's Rights, I am not very familiar with that convention, whether that Article 16 is one of those unenumerated rights. I think the Article 19 that you had invited me to was very explicit that they are tenable to the extent to which they are not inconsistent with the Constitution. So if the question was whether or not they can get married, I would say it is not one of those rights that are protected. But if the argument is that we want to be recognized as a family, then I think the matrix of the issue would be completely different. Probably then there would be an argument around it, Commissioner. Okay. The question was very long. I have tried as much as possible to answer it. I don't know if I've answered it.
Yes. So I tried to set the context because there are no, sometimes there are hard questions that are presented before the court and that the court should answer. Now I want you to take to Article 49 on freedom and security of a person.
Yes.
So Article 49 provides that every person has the right to freedom and security of the person, which includes the right not to be, and for purposes of my question is D, subjected to torture in any manner, whether physical or psychological. So physical torture is fairly, something, it's discernible.
Yes.
But psychological torture might not be, immediately discernible. So you have and this possibly we practice it when we were younger, where we were, as children, we did not have a choice to the oath of allegiance. I pledge my allegiance to the President and the Republic of Kenya. You remember that?
Yes.
Or salutation of the flag.
Yes.
Now, would you say that forcing children, to do oaths of allegiance or to salute to the flag, without having the choice on participating in those activities, would amount to being subjected to torture, whether physical or psychological? Because it's not a choice that you have, particularly if you're in school. I don't know whether it happens right now, where you are told, salute to the flag, or it's at 6 p.m. the flag is about to be lowered, stand up and be at attention, or do the loyalty pledge.
Okay, so can I answer?
Yes.
My answer would be, I understand your question to be particularly in respect to the flag. You didn't say what flag, but I assume it would be the national flag.
Yes.
You also said pledge. I assume it is pledged to the country rather than to an individual, or to any religion. To the extent, therefore, that you are dealing with national symbols and national concern, I would think it is more of patriotism than a question of torture. That's one. Number two, I would say, since your question is very carefully cross-referenced with children, that children being people who are being molded, it is right that they should be subjected to develop a sense of patriotism and loyalty, and I wouldn't see anything wrong in subjecting the children to appreciate the importance of patriotism and loyalty as they grow. And lastly, you tie your question with the question of torture, both physical and psychological. My understanding would be that torture is a relevant part if you intend to extract something out of it. In the situation of the children, I think it's just teaching them where priority, where importance, where values exist. It wouldn't seem to me like anything is being extorted out of the children. They are not being asked to make any confession. They are not being asked to sign off any rights. They are not being asked to surrender anything or to give anything. And to the extent, therefore, that it is part of education and development of the children, I would contend that it is a legitimate conduct.
Okay. And lastly, if you look at Section 3 of the Supreme Court Act, provides for the object of the Act and makes further provisions with respect to the operation of the Supreme Court and its final judgment.
Although I can't say for us absolutely that it has been determined by the Supreme Court. I think it's the issue of trust on land. Being that where you have a family member being registered in the course of adjudication and other types of registration, being registered as the owner of the land, it shouldn't be perceived as if that is the only owner of the land. It should be treated as a trust on behalf of the family, on behalf of the other family members, and that it is being held by the person whose name is registered in trust for the rest. The other one is probably also trust in relation to matrimonial
Very much. We now move on.
For example, or for instance, there is a pervasive understanding of what constitutes public interest. And rarely do courts differ on what constitutes public interest. But we cannot say the same of general public importance. So as you answer, you may kindly also tell us whether there is a difference between public interest and general public importance, and whether or not there is a need for jurisprudential coherence and guidance on the same.
As usual, AG asking me the toughest question. So let me start first of all by saying I would have thought the Supreme Court, because it has reiterated this, I know every other person wants a chance at the Supreme Court, and so there have been so many applications to the Supreme Court. And I think the Supreme Court has been very consistent in saying that for general public importance, the criteria is number one, that the issue you are seeking the court's attention for should transcend your personal dispute and should be a novel issue that needs resolution and will be used by other parties. And thirdly, that it should have escalated from the courts below to the point of the Supreme Court for determination, that you do not jump onto the Supreme Court and ask them for a determination when it has not graduated and escalated through the courts below. Now, you are then, I also wondered whether your question was also whether the court has settled jurisprudence on whether they can consider interlocutory applications. And my reading of it is that initially the Supreme Court had said we will not deal with any interlocutory application, we will only determine when it has yielded a judgment. But then with time, they have put some riders where they have allowed interlocutory applications even when the substantive hearing has not been determined. Now, on the specific question of public interest and public importance, that was the question, Honorable AG. Public interest and public importance.
Whether there is a difference in definition or understanding.
I would contend that public interest and public importance is one and the same thing, especially for purposes of the determination of the question for the Supreme Court of a matter of general public importance, because it would be both in the interest of the public and of importance to the public. Whichever question they have to wrestle with would be one that has been distilled as being one that the public is interested in and is very important for the public. I know the concurrent argument between the competition between public interest and I think national interest, but that's not your question. But I would say, in answer to your question directly, for purposes of Supreme Court, for purposes of Supreme Court's jurisdiction on a matter of general public importance, I think I would deem and consider any matter that is of public interest and public importance to be one and the same for purposes of the courts.
Who manages your wealth, legacy, and connects you?
Made a mistake? And if so, would they have done anything better? If you can identify one or two. I'm not saying they have. I'm asking you whether you think there are cases where they have made a mistake, and if so, would they have done better?
Okay. It is an unfair question because I'm a candidate, but let me answer it all the same. Murwatetu 1, I think, could have been done differently. Because
Unatazama Mwangaza TV, tumaini lako. Unapozungumza kama mtazamaji, tunakusikiliza na ndiposa sasa tunakuletea neno la kiunabii, mafundisho ambayo yanakupa mwongozo wa kimaisha, matendo makuu ya Mwenyezi Mungu ambayo yataijenga imani yako.
Kama kuna pepo baya, pepo tunataka tuikemee, ni pepo ya ulimi. Sema pepo ya ulimi. Kama tunahitaji deliverance, ni deliverance ya ulimi. Kama tunahitaji tubadilike, ni ulimi ibadilike. Kwa sababu kile kinaharibu watu, kile kimeharibu washirika wengi hapa, kile kimeharibu hata wamama wa kanisa na wazee, ni ulimi. Sikia hapa, jiosheni, jitakazeni. Kujiosha si sabuni na maji. Kujiosha ni kuondoa kuokoka, kuacha hizo dhambi mbaya, kuondoa hiyo vitu ambazo zilikuwa na kufuata, hiyo umalaya, hiyo usherati, hiyo mambo ulikuwa uondoe, ndio mpatane na Jehova. Uambie Mungu, nataka kubadilika, nataka kuwa kiumbe kipya.
Yote kiandaliwa na kanisa la Jesus Winner Ministry Roysambu chini ya Askofu Edward Moi. Ni kila siku saa 11 alasiri hadi saa 12:30 jioni, Jumatatu hadi Alhamisi.
Mwenyezi Mungu, Mungu wa majeshi asema hivi: jipeni moyo mliovunjika moyo. Yes. Mliokaa kama mmekufiwa. Ndio. Mliokuwa kama mmegojeka. Yes. Jehova ananiambia. Ndio. Jipe moyo. Yes. Jipe moyo. Ndio. Jipe moyo. Jipe moyo. Jipe moyo.
Neno la kiunabii.
Kumbe hata unanipigia ushafika. Mko vipi?
Tuko salama kabisa.
Ndio mmeingia saa hizi? Funguo ziko wapi? Una driving license?
Niko nayo.
Hebu nione kwanza.
Niko na experience ya Shakameka.
Wow. Oti, fungua gate. Shuka kwanza. Leta funguo. Kwani nikuulize ulisoma wapi kuendesha gari? Umeniambia unajua kuendesha gari, aibu angalia vile ambavyo unatarisha maisha ya watumizi wengine wa barabara. Kwani wewe?
Nasuliniambia unajua kuendesha gari. Wewe na shaka metamko hivi. Nini imefanyika?
Hebu ingia, nataka nikupeleke Jewel Institute of Advanced Driving School. Utende ufanye refresh. Kusema kwamba ujikumbushe. Hebu ingia hapo hivyo twende.
Excellence and quality driving school instructions is what Jewel Driving School offers. It gives you an experience like no other, accredited by NTSA. A driver's safety comes along with careful driving, bearing in mind other road users and pedestrians included. We offer theoretical driving classes, executive classes and refresher courses. We offer training on both manual and auto transmission vehicles, and our training are based on the new NTSA curriculum. We are located 5th floor, Jewel Complex, Roysambu, next to TRM Thika Road. Come join us and experience a driver's confidence. Jewel Driving School. Drive with confidence.
Ukitaka mali safi kuja Kemuma, CCTV utapata Kemuma, mulika mwizi electric fence utapata Kemuma, automatic gate utapata Kemuma, fire system, alarm system, fingerprint hapa, automatic gate, mali safi, kila kitu ya security ni Kemuma. Tumetambulika Kenya nzima Kemuma. Twende nalo Kemuma. Njoo na mi twende Kemuma. Vitu ni fresh mali yote fresh. Hapana deal na mtumba, kila kitu ni fresh. Ukitaka mali safi njoo na mi twende Kemuma Engineering System. Wa security tuko fiti, hatuna competition, wanajua tuko fiti. Suka
Kemuma Engineering Systems. We mind your security.
Unatazama Mwangaza TV, tumaini lako.
Mandatory death sentence is wrong. Is as constitutional impropriety. When it was made, when a finding was made to that effect, the consequences, the Supreme Court was not necessarily saying go and apply it retrospectively. It was just saying. The way I would understand is that nobody had brought this thing earlier, but now that it has been brought, we are making this finding today on the 28th of April. How then it will roll out is a question. It is. I don't think it is part of their mindset that we intend to have it to apply retrospectively. Of course, I appreciate that orders were made for reconsideration of sentences, but I think it doesn't quite fall on the four corners of the law of retrospectivity, because the law of retrospectivity refers to the enactment of a law. What the Supreme Court was doing was a question of making a finding on the face of the provision as to whether it was right or wrong, regardless of the timing, whether so much time had passed or not.
Thank you.
Thank you.
Thank you very much, Honorable Attorney General. Now we move to Justice Murima.
Thank you so much, Honorable CJ and Judge. Once again, welcome. Let me take you back to the discussion on GPI under Article 163(4)(b), and a number of decisions from the court position, which I totally agree with. Now, room to go to the Court of Appeal, and courts have decisively said you cannot assume jurisdiction, so there's no way you can go to the Court of Appeal. And as a result of that provision, we have seen so many conflicting decisions in the High Court from several issues of law that, in as far as we know, the window for resolution of conflicting decisions is open before the apex court, from the High Court, so to say, to the apex court. Now, the question is, do you think, in consideration of public interest, the Supreme Court, for purposes of resolving conflicting decisions, maybe in the High Court or tribunals, which exercise final appellate, the Supreme Court, and deal with them?
Thank you, my Lord. I think from my reading, the Supreme Court, the Supreme Court has, but in a normal litigation, then you can't enter the Supreme Court without passing through the Court of Appeal. I wasn't sure I got your question, because you started by saying small claims court, and I saw you almost said MCS also, because I think also MCS enter the High Court. They can't go beyond there. And the question you're asking is where there are conflicting decisions, whether they should go to the Supreme Court. And just for clarification, very kindly, Commissioner, are you limiting your question to the conflicting decisions in small claims issues, or generally on issues that cannot escalate beyond High Court?
Let's be general.
Okay.
I brought in the issue of small claims as an example.
Okay.
But it's a general question.
Thank you very much. Yeah, of course, the other example would be the MCS. This is the way I would answer, my Lord, that I would think the Supreme Court would have jurisdiction if there is a genuine matter of general public importance in any of those issues, being a real identifiable issue that they need to resolve, rather than a question of merits. And if it were to be the case, as you say, that there is concern that there is strangling of some causes not to go beyond High Court, I would see a petition being framed to cover, including the concern you have, that one, either the question arising from small claims courts is this, it is a matter of general public importance, or this issue in the MCS elections is of general public importance, and ask the High Court to determine whether they are substantive enough and to apply their minds. So there would be then a determination on two things. It is framed, it needs all the issues just need to be placed on the table, and they need to show gravity on the face of it. Because I would see, if it is a question of small claims, it doesn't matter that it is it doesn't matter that it is a matter of small claims. It doesn't matter that the policy for small claims is finality of litigation. What matters is that if there emerges a very significant point that needs consideration by courts, and then it can, I think it could still escalate depending on how it is framed.
Now, Judge, if I get you right for clarity,
yes,
do I get it that you maintain that such an issue, even after you are satisfied that is an important question which needs consideration by the SCOC, you will give more credit to the process and maintain that you can only frog from High Court to the Court of Appeal to the Supreme Court? Will you be looking at the process more than the substance of what? Because that may go contra 159 article.
Okay, first of all, let me just answer your question directly, my lord, that I insist you cannot leapfrog. And the reason why it is necessary not to leapfrog is because it needs consideration by the Supreme Court after the other courts have considered it. You can't fly it over to the Supreme Court before the other courts have considered and applied their minds and possibly resolved it.
Yes, so sorry for engaging you. I agree, yes, but this is a matter which does not need any clarification, any further clarification. The Supreme Court has already said if there is an issue of conflicting decisions, that's a matter of GPI. The issue is settled, it's clear. It's just a matter of taking it from the High Court to the Supreme Court and say, this is one of those you say.
Yes, my lord, but I think there are still some cures. For instance, if there are conflicting decisions, and that happened in the issue of statutory notices, they had to set up a special panel right from the High Court to the Court of Appeal before then it go to the Supreme Court. Okay, at that time there was no Supreme Court before it would go to the Court of Appeal. The issue of the other one was the issue of arbitration. So that it is not good enough to just say one High Court judge says this, the other High Court judge says this, so there is conflicting, let's rush. Or that one bench of the Court of Appeal says this, the other one. I think there is still that aspect of saying, let's now constitute a bench of, say, 5 or 7 judges, either the High Court or the Court of Appeal, to give it a thought before it gets to the Supreme Court. I still insist, my lord, that even in terms of policy, it would be disadvantageous if somebody just walks to the door of the Supreme Court and says, I have these two decisions, please decide for me, before it escalates. So if you have a bench which has been decided by 333 in Court of Appeal, and you constitute a bench of, say, 7 or 9, the likelihood is that the assembly of those minds probably will resolve the issue and harmonize it. And if there is no agreement, it can still escalate. But I would think it is right to say just because there is a disagreement, you walk over directly to the Supreme Court. Even as a matter of fairness. I know the Supreme Court has said that, but even looking at it as a question of jurisprudence, it's better if it just escalates. And all the minds have gradually considered it.
Okay, we can hold it at that. Yes. Though to me it may not be an issue of jurisprudence because it's an issue which is already settled. It's already clear that conflicting decisions are matters of general public importance, but we can hold it at that. Let's get to elections. We are some few months into general elections.
Yes, my lord.
And do you think, Judge, there's a difference between general elections, fresh elections, and a runoff?
General election, fresh elections, and?
And a runoff.
Runoff.
Yes.
Okay, so runoff would be a situation where nobody garners 50+1 in a presidential election, in which case then the top two candidates would go into runoff. General elections is the standard cycle of 5 years elections, and fresh elections is where elections have been nullified and parties have to go back, or rather a constituent entity, either county or constituency, needs to go through another election.
That's very right, Judge. Now, I want us to consider an issue. I believe it has not arisen yet, but it can arise. And let's take a walk to a fresh election. And let's start from a point where a petition challenging a presidential election is filed in the Supreme Court. The position which has been taken by the Supreme Court is that in the event a fresh election is called or ordered, it is only the petitioner and the president-elect who should take part in that fresh election. We are together, so that end, Judge?
Yes.
Yes. Now, let us take it this way. A petition is filed before the Supreme Court challenging the election of a president. And a candidate, an unsuccessful candidate, decides not to file a petition, but with the leave of the Supreme Court, this candidate is allowed to join in these proceedings, in this petition, as an interested party. An interested party has identifiable stake in this matter and has the right to file pleadings.
Yes.
And in these candidates' pleadings, it's stated very, very clearly that I'm in total support of this petition. The election has to be nullified, and once nullified, I am interested to take part in the fresh election. So, the position of this candidate is clear, that I want to take part. He has not exercised his or her position in that he has stated very, very clearly in pleadings that if it is the petition succeeds, I also want to run. But the jurisprudence which has been developed as a term is that it is only the president-elect and the petitioner. And the reasoning has been the rest of the candidates, as long as they have not shown any interest, they should not take part, which I agree. But this is a situation whereby this party who has been allowed by the court to come in as an interested party has expressly stated that its intention to run, and eventually the election is nullified and a fresh one called. Will this interested party be able to take part in that fresh election?
Thank you, my lord, for the question. We need to, okay, so your question, as is the nature of always illustrative scenarios, the question doesn't come out as to whether the petitioner is a candidate, But I want to, and it is easier for me to answer the question if you don't. I don't have an answer to that question, because then we would then be looking at it and saying, what of if the petitioner was not even a candidate? He's just a public interested litigant, and you are declaring that parties must go back for fresh elections. There has to be other candidates. So I would say in the scenario you've made, the candidates, so long as a person was a candidate in the elections leading to the nullification, they are eligible to participate, unless there is a specific reason why not.
Let me get to
Yes,
Judge.
Yes, sir.
You're saying in a fresh election,
yes,
all candidates are eligible to take part. If I get you right, that's your position.
It depends on the nature of.
No, I limited myself to the position taken by the Supreme Court, which is a case premised on the petitioner being a candidate.
Okay.
And the court said it is only the candidate who is the petitioner and the president-elect. But now I've introduced a further element of the interested party.
Yes.
And the reason why the Supreme Court says the other candidates should not participate is they have not taken any active step in expressing their desire to run in the fresh election.
Yeah.
But this is an interested party who has said, I'm interested. I filed my paper, I support this petition. And if it goes through and a fresh election is called, I'm interested to run. So they cannot be said to have exercised their position. They have stated clearly that I need to take part in the fresh.
My Lord, I would think that if an interested party has come and said, because an interested party, first of all, is one who has a stake and will be affected by the decision.
Yes.
If he is a significant player and it's obvious that he's a significant player because from your illustration he was a candidate, then it is my view that he is eligible to participate in the elections. Because look at a scenario where you have 5 presidential candidates, and when you cascade votes, probably the one who has come to court was the one who got the least votes. And the Supreme Court then says the people who are going to participate are only the petitioner and the president-elect. It would be just unreasonable. It would be awkward. So I would say if somebody has come and explained himself why he did not petition, what his stakes are, what he considers to be his rights, and considering that it is a question of democracy and representation, I would take the view that an interested party who has made that expression should be allowed to participate in the elections. And I'm comforted by the fact that the point you're making has not been quite directly dealt with, being the question of whether an interested party who comes and says, I want to participate, my explanation for not having filed the petition is this, these are my stakes. To the extent that it hasn't been addressed, and being an open question, I would say my view is that if he should be allowed to participate because he has come and represented his concerns, and if he can demonstrate his case, then he should be allowed to participate.
Thank you so much.
Thank you too, my Lord.
I believe that should be the position. Looking at the issue of access to justice, limiting costs, and many other parameters. Thank you for this rather long engagement. I wish you the best.
Thank you very much, ma'am.
Thank you, Commissioner Ngutia.
Thank you, Chair. Good afternoon once again, my Lord.
Good afternoon.
It's been a long day so far.
It's okay. It's okay.
Yeah, they say Kenyans know the Supreme Court to be the court that only deals with presidential petitions. So I understand why Judge Murima had to take a lot of that time. So, Judge, you did submit submissions that you have handled at the Supreme Court and High Court on matters touching land, criminal case, arbitral award, and a constitutional petition appeal, and also shared a no case to answer motion filed before the International Criminal Court. The exhibit excellent issue identification, coupled with strong ability to link facts to applicable legal principles. And looking at the ICC matter, where you submitted on the need for clarification on application of the no case to answer principle within the ICC framework vis-a-vis common law jurisdiction, I find the arguments novel, so I commend you. Have you since delivered any decision at the Court of Appeal or decisions?
Yes, I have.
Okay. I know my colleague will ask you around that. So allow me to ask you two questions.
Yes.
Of elections, because the Supreme Court does so many other things beside the elections which Kenyans are usually keen on. Key strength in arbitration is finality, and that is why you find most laws on arbitration clearly provide for this fundamental principle. In the New to Aggravate case, the Supreme Court was confronted with what is described as question of considerable public importance touching on the interface between arbitration and the appellate jurisdiction of the superior courts in Kenya. So what the court held is that Section 35 of the Arbitration Act is silent on whether an appeal should lie to the Court of Appeal, and this is what it held in part. Allow me to read. An appeal may be allowed in very limited circumstances where a manifestly strong decision was made, specifically where the High Court, in setting aside an arbitral award, has stepped outside the grounds set out in Section 35 of the Act and thereby made a decision so grave, so manifestly wrong, and which has completely closed the door of justice to either of the parties. So how would you describe the reasoning of the court by creating this exceptional circumstance vis-a-vis the general principle of finality in arbitration? Was the court trying to cure any lacuna in the Arbitration Act, or did it risk undermining the fundamental principle on limited court intervention in arbitration? Maybe you can give your explanation to your responses.
Thank you, Commissioner. Yes, indeed, in that case of Nyutu, my recollection of reading it is that one of the issues the court had, so the court was dealing with about 4 issues. The first one was whether the court can infer existence of an option to appeal when I think it is Section 35 is silent. On whether a party who has gone to court for adoption of an award can appeal to the Court of Appeal. And so the question was just very directly whether in the absence of clarity, in the absence of a direct statement on whether or not there is right of appeal or not, the Supreme Court thought that such an option to appeal could obtain. And reading that judgment, my understanding was that then the court was wrestling with a competition between 2 issues. One is the right of any litigant to a fair hearing, which is a constitutional right, and on the one hand, by the party who wants to appeal. The one party who wants to appeal saying, my rights to fair hearing have been violated, I need an opportunity to ventilate my case. Vis-a-vis the counter-arguments from the other side saying that the policy and intention of arbitration clause is to achieve finality and sooner resolution of disputes. And in some, my understanding of how the Supreme Court arrived at its decision is to balance those 2 rights. One is the right to be heard and a right to challenge a a situation where the decision of the High Court is so manifestly wrong on its face vis-a-vis the desired intention of the two parties that there should be finality. And as a consequence of balancing those two interests, then the Supreme Court said that you will only appeal to the Court of Appeal where you are able to demonstrate that your situation is very distinct. It's not just the usual issues of disagreements or dissatisfaction or ordinary displeasure. You have to distinguish a very remarkable dissatisfaction with the way the High Court has dealt with the adoption of the award. And so that's why it is restricted, and that's why, to my mind, it requires leave, because that leave stage is where the court then will will evaluate whether it is an ordinary displeasure or it has a very distinct legal or factual issue.
So according to you, it does not in any way undermine the statutory design of that particular provision?
It doesn't undermine, and it prioritizes fair hearing and justice to all parties.
Okay, I'm satisfied with that response. And number two, the case of Mitubel Welfare Society versus Kenya Airports Authority. I know you know the facts, but what the court held is that structural interdicts are recognized reliefs in human rights litigation, and Article 23(3), sub-Article 3 of the Constitution, particularly when it comes to enforcement of social economic rights such as housing. In this particular matter, the Court of First Instance had issued structural interdicts. The Court of Appeal overturned the decision, saying that the structural interdicts were not part of Kenya. So the Supreme Court affirmed that indeed they are applicable in Kenya. However, sometimes this year there is the Omtata Tribunal's case. I think it was Omtata versus the National Assembly, where the court in the first instance had issued a structural interdict directing the National Assembly to come up with a tribunal's bill. And what the Supreme Court did is set aside that structural interdict that had been given against Parliament, and it held that in part, structural remedies must remain exceptional, proportionate, realistic, and restrained, and that judicial intervention in legislative process is justified only in the clearest of cases. So it appears there are different standards the Supreme Court has given for executive and legislature. So I would want to hear your views on whether we should maintain that the standard for judicial supervision on legislative processes should be higher than that of the executive supervision of executive compliance of court orders. And if so, what is your basis? What is your response, if it's yes or no, and give your explanation.
Thank you, Commissioner. So first of all, let me just answer the last limb of your question directly. Yes, I would think that there is sense in expecting structural interdicts to weigh more on the executive and to weigh less on the legislature. And the reason for that contention on my part is that the executive is assigned the function of executing either what the legislature has determined or what the judiciary has made a finding on. And so when it gets to the executive, it is more of executing it rather than evaluating, weighing, applying discretion. Theirs is really to do it rather than it could entail a question of how to do, but not whether or not to do. And that's why in structural interdicts, then the executive would be told, please come back to us with your timetable of how you intend to implement what we have decided, how you intend to implement it. Then it is evaluated and then it is managed. So yes, I would say there is, thinking on my feet as you've asked me the question, I would see legitimacy in requiring the executive more to comply with structural interdicts and to be more restrained in asking of it from the legislature. Now, going to the legislature, why I would say there would be need for more restraint in respect to the legislature is the legislature is a judgmental structure like judiciary. They have their wisdom, they have their judgment, they have their discretion, they have their values. And they do that not at a personal level, but at a representative level. And so it cannot be right that a structural interdict is placed on them to say, pass a legislation that removes, and just for illustration purposes, that say remove members of parliament from CDF. All you can say is we declare a CDF with members of parliament in it unconstitutional and leave it to their judgment how best to take on board the observations of the court and to circumvent the concerns that have been issued. And so there is equality, there is a sense in which the legislature, I'm not saying the executive is any less, but the judiciary and the legislature are institutions which apply their minds, discretions and judgments. And the judgment of the court should, in my view, it might not be appropriate for the court to attempt to use its mind and its value considerations and impose it on Parliament without giving them room to apply their wisdom. Because then it would violate separation of functions, it would amount to micromanaging the legislature. And probably just two more observations about it is to say that the general nature of how the courts deal with legislative output is to wait for it to be finalized. You don't go in and say, do your second reading today or take it to public participation today. You let them run the whole process, and when it comes to court is when you evaluate whether it was done properly or not, whether there was public participation, whether it went through all the stages and all that. And so structural interdict would have that inverse effect. It would have the inverse effect of seemingly micromanaging the legislature. And lastly, being a fairly later decision from the Supreme Court, I sometimes wonder whether the lessons from the case of over 30% gender representation in all government entities, including legislature, where the court had said you must immediately apply the 30% plus, and it has never been achieved up to today. Whether that was a lesson also to say, handle only what you can handle and issue orders which you can actually execute, that you should not place yourself in a situation where you issue orders that you cannot, that you might not be able to implement. And the other one is the point made also somewhere in the Murwatetu cases, saying that the legislature has the right to decide what is criminal and what is the punishment. The court will only come in to gauge, but not to tie the hands of the legislature. And for all those reasons, then I would say yes, it's probably legitimate to expect structural interdicts to weigh more against the executive, and it is also legitimate for the court to adopt a posture of being more restrained in seeming to tie the hands of the legislature. I hope I've answered your question.
Yes, I'm okay with that response. And yes, you cannot control what happens in Parliament, and some bills, some parliamentarians can oppose.
Yes.
Lastly, based on Honorable Attorney General's question on if there are certain decisions of the Supreme Court you don't agree with, I just want to read you a phrase here. Respect for precedent must not mean refusal to re-examine wrongly decided cases. If appointed as a Supreme Court judge and having identified some of the gaps in in matters that you have listed, would you be in a position to, depending on what comes before you, to re-examine wrongly decided cases as a Supreme Court judge, as a bench?
Yes, if it is wrongly decided, okay, first of all, of course, the starting point is to say that it is a collegiate environment, so it's not a question of walking in and calling up files and changing things. It is a question of the environment. That's one. Number two, I think it is a question of every case has its own facts, so it is very difficult to say as an absolute. But even looking at the conversation we've just had, the question you gave me immediately before this, you could possibly argue that the Supreme Court is being more measured in how it is relating with the legislature in this decision of Okiya Omutata, saying we need to respect each other's space. And so it is a point to say that every subsequent day is a day of learning, and every subsequent day is a day of a new revelation of how better to do things and how to make corrections. Lastly, Commissioner, is to say that the law is I think the Constitution is very explicit on that the only entity that is not bound by its decision is the Supreme Court, but the others are bound by the Supreme Court's decision. And I think then that gives latitude to the Supreme Court to be able to reevaluate their decisions, the circumstances, the issues, and improve on the laws and the legislature and jurisprudence, actually jurisprudence.
Okay, thank you, my Lord, and all the best. Thank you, Chair.
Thank you very much. We now move on to Justice Joki.
Thank you, Chair. Let me just move on a little bit from where Commissioner Ngutia has spoken. So, yes, sometimes Supreme Courts must reevaluate and review, but because, like you said, their decisions bind other courts below, how do you balance the ability to review with the need for certainty in the legal system? That's the first question. Another question coming out of your discussion with Commissioner Ngutia is the issue of collegiality. And I wanted to see if you can just let us know what you think are the key elements of collegiality. And assuming you come into the Supreme Court, if we listen to a matter and you have a very strong opinion about it, in fact, you have a completely different opinion from the majority, what steps do you take either to persuade other judges of the court or to make your opinion known in a manner that is collegial? Let me start with those questions.
Thank you, my lady. On the question of review vis-a-vis the need for certainty, I would think the cure for that is to say that the Supreme Court and the cure for that is just the need for extensive reflection and evaluation of the issue, so that by the time a decision is being made, it is not a decision that probably by the break of the next day there is concern that we rushed into making a decision that we cannot stand by. So my answer is, in the quest to maintain certainty, the pressure on the Supreme Court is to be very diligent in reflecting on what the issue is and to make a decision that will last and will outlive time and other issues, to be as circumspect as possible, to reflect on all possible implications of other laws, the Kenyan situation, the constitution, jurisprudence, both national and international, and to come up with something that in good conscience the Supreme Court is satisfied will stand the test of time and the test of issues. That would be my answer. On the issue of collegiality, and the question is whether what I would do if I have a strong opinion, how I would integrate it in an environment which warrants the need for collegiality. I would take the view that the issue in every collegiality environment is the need to discuss, make your point, attempt to persuade, and see if you can arrive at an understanding. The point being that there is a possibility that even as you carry a strong point, there's a certain perspective that you haven't looked at, so that there is need partly for you to communicate what your concerns are, and also to be pragmatic enough to listen and evaluate the points made by other people, and probably arrive at a common ground. And so my answer to that is that the need for civility and honest discussion and this discussion frankly and in depth, that you should also be diligent. You don't carry a strong opinion when you have not quite exhausted the scopes of the issues. If at the complete tail end you are completely unable to agree, but you have taken on board everybody's view, but you still think that your point has legitimacy, I would think it is possible to write your own opinion or your own judgment, but then that should be the very last option after having honestly considered, having articulated your point and having honestly evaluated other people's views.
Thank you very much. If we can just move a little bit to jurisprudence and jurisprudence, which it is supposed to, according to the Constitution, in terms of the presidential election, electoral jurisprudence, or electoral jurisprudence generally. What is your opinion in terms of any development or any contribution the Supreme Court has made to electoral jurisprudence from 2013 up until now? There have been a number of elections. Has been up until now. There have been a number of elections. Has the Supreme Court any electoral jurisprudence? What is the extent of that? Or have we done none at all? Have we been consistent? Yes. Have we been... I would like to hear your opinion on that.
Okay. So, I think the consistent position that the Supreme Court has taken, there are issues where there has been change, and I'm particularly referring to the first election of 2017, when there was a different approach. But the 2013 elections, the October 2017 and the 2022, I think you could almost say they have some similarities. And the similarities would be the criteria. First of all, let's say the standard of proof being that it is a standard of proof referred to as intermediate, being neither beyond reasonable doubt nor to the lower scale of balance of probabilities. It's somewhere in between there. except where two issues are being argued. Either allegations are being made of criminal ledger when then the standard of proof is higher to the standard of beyond reasonable doubt, or where arguments are being made that the data does not meet the requirements of the Constitution being 50+1. I think the law says then you need to prove that point beyond reasonable doubt. So beyond the reasonable doubt on criminal allegations and on allegation that the faults do not amount to the numbers and criteria required for declaring one elected. The other one is the other one that has been consistent through the period has been that the elections will not be nullified merely because there are some legal infractions, that some aspects of the law are not followed. The court will look more at the principle whether there is a substantial compliance with the law and the defaults do not affect the results. If the infractions are not so grave, and if on its face they do not affect the results, then the elections are to be upheld. And this is informed by the general proposition that elections being a human activity, there will always be challenges here and there, and there will always be a problem with one legal compliance or the other. And so the issue is more to look at the substantial and to give the wishes of the populace, to give right to the wishes of the populace, that if the court is satisfied that the wishes of the populace has been achieved by the elections, then it is sustained. The third one, I think, from all the elections is that progressively we have, the elections have been technological, using the integrated system which is used for purposes of registration, identification and transmission. That even when technology is used, it needs to be auditable. It should be possible to audit them to confirm that they are transparent, accountable, and they reflect the wishes of the people and they have not been manipulated in the course of it. Now, the outlier case of 2017 August is that in that case the Supreme Court took an approach that they then subsequently came back to in October and 2022, or rather they abandoned, and they went back to the 2012 position, being this, that in that case the Supreme Court said that the only thing we are interested in seeing is whether the process was right. And the moment the petitioner has persuaded us that the process was not right, the question of whether or not the votes were properly counted, whether they were properly verified, whether they were properly collated, is irrelevant. We will put our full stop at the point of the process. If the process is faulty, then that is the end of that. And I think in that case, the issue was not so much that the elections were faulty. The issue turned on an order made by the court that the IEBC should give access to the servers and the logs. And IEBC, I think there were issues of saying, we here in Kenya, we are at 1 o'clock. In France, where the servers are hosted, it is midnight. Anyway, basically, there was no access to the servers and the logs. And the court said, we will draw an adverse inference against the IEBC and the respondents, in the sense that their refusal to give us access to the logs and the servers is an indication of the possibility that the integrity of the transmission of those results was not proper, and therefore that process is nullified. I am aware that there was also a very huge argument around it on the question of the conjunctiveness of section, I think, 83, which is the same issue I was saying. Whether there are two standalone requirements in that section 83, One aspect being that you comply with the law 100%, and the second one, that the results have not been affected, that you have to demonstrate the two. In that case, the court said they are disjunctive. You have to prove each of them separately. But then subsequently, they said it is one requirement. Even if there is fault, you still need to show that even that default did not affect the results. Lastly, my lady, is that in all the elections, the court has maintained the position they took in 2013, being that rejected votes do not count in determining 50+1. And the court's position was that when it is rejected, and most importantly for purposes of a petition, that vote does not benefit anybody. So you cannot say one person benefited against the other. It's rejected, it doesn't count, it doesn't inform the 50+1. So 50+1 is all the votes excluding the rejected votes. I know I said lastly, but probably allow me to just say this one being the very lastly one, that in 2022, the same question that arose in August 2017 arose, being in 2022, whether the results could be verified, particularly transmission, and whether there was interference with Form 34, I think 34A and 34B, or 35A and 36, I'm not sure. But basically whether the forms that were on the ground are exactly the same ones that were transmitted and are the same ones that informed the data that was announced by the IEBC. And unlike August 2017, in 2022, IEBC gave full access to the servers and the logs, and as a result of that process, the reports were filed in court from the petitioners, the respondents, and the registrar. And the court then was satisfied, unlike in 2017, that indeed we are able to verify, and the court was also able to compare the forms, which I'm not sure whether they were 34, 35, or 36.
That I think is sufficient.
Okay.
Let's move from domestic law to international criminal justice, which you say you have experience in, and that therefore you make a contribution to the Supreme Court. The International Criminal Court, which you're familiar with, uses a hybrid system of common law and civil law. So how would we here in the Supreme Court find that beneficial, or how would we be able to export our jurisprudence? How would that be useful? If you can just explain.
So I think, as AG has always said, the world is a global village now because of migration, the technology, and others. And if you read an article, the scenario now world over is that there's a lot of borrowing between civil system and common law system. And as a result, therefore, the original clear lines between the functions of the conduct of proceedings under civil law and the conduct of proceedings under common law have somehow gelled. I could pick one scenario, for instance. So under civil law, a judge is not an arbitrator, is not neutral, is not just a quiet chair waiting for two people to battle it out like in common law. In civil law, a judge is an investigator. It is inquisitive, it is inquisitorial. So that a judge in a civil process can order the calling of a witness, production of a document, and things like that. In adversarial system, in common law, the ideal judge should be one who lets everybody make their case. And even if the judge were to see that at a certain point, a certain case will be disadvantaged because a certain party is not being diligent or is being careless or is frustrating his own case, the judge would probably still have to keep quiet, because short of that, then you would be seen to be taking sides. Now, when you come to the functioning of the oxygen rules, I think Section 3 or Rule 3 in the Court of Appeal and Rule 1 in the Civil Procedure Act and Article 159 of the Constitution, when you look at those, the requirements of those sections, it is such that it requires the judge now to come out of that very neutral position and to say, what is the justice of this issue, both in terms of procedure and substance. And if injustice will obtain as a result of keeping quiet, the judge is entitled to, on his own, or to require the parties to participate in ensuring the court is fully informed on all the facts and the law, and to arrive at a decision. And so your question, my lady, was where does common law and civil law meet, and what is the necessity of it in the Supreme Court? I would say that indeed progressively the two systems have borrowed from each other. Even when you look at the case of LGBTQ, some of the cases that were quoted in that case are cases that emanate from systems that are that practice civil law. So indeed, civil law is here and is with us, and it's a reality.
Thank you, Judge. Finally, I'm just conscious of time. You know that the Supreme Court is managed on a regulatory framework.
Yes.
What are the challenges, if any, that when you look at the Supreme Court, it has in its regulatory framework? And there have been proposals over the year that there needs to be some constitutional amendments to the structure of the Supreme Court, including to increase the numbers of the Supreme Court, to bring a limited term to the Supreme Court, for Supreme Court judges not any term, because it's such a political court. Also, that this issue you are discussing with Justice Mrima, whether you can leapfrog certain issues like constitutionality of statute, that perhaps it should leapfrog from the High Court to the Supreme Court, and also the budget of the Supreme Court, that in other Supreme Courts they have an independent budget, and that's not the case here. What is your comment on these kind of amendments, and do you have anything else that you would look at the regulatory framework and say, this is the direction in which the Supreme Court should do, and if you come to the Supreme Court, that you'd be able to support such change?
Okay, so the question is more administrative than legal.
Yes, we have now moved from legal.
Okay.
We are still an institution.
Yeah.
We have our administrative issues.
Yes. I think the other suggestion also was to ask that the Supreme Court number, the number of judges should be increased from 7. I think that's one other suggestion.
Oh, and one final, that the number of days to listen to the presidential election petition should be increased. What do you think of that?
Okay, okay, so I'll just answer from my feet, because it's not something I've really thought about. I know the discussion has been more in the nature of the numbers of the Supreme Court number of judges. But then your question would be on the leapfrog. I think I maintain the position I took in my conversation with Justice Murima, being that the Supreme Court is one more mind, one more set of minds on an issue. And it is better if by the time it is scaling to the Supreme Court is able to look panoramically at all the thoughts that have gone into the issue and to be able to adjudicate and give directions. And so I would still restrain myself from saying the leapfrogging would be a wise thought. On the issue of 10 years, yeah, probably it's a good idea. And I'm just answering this on my feet, my lady. It's not something I have thought. The other option is probably to do what ICC does. The ICC doesn't have so the ICC has 3 levels. It has a pre-trial level, it has a trial level, and it has appeal level. But there are no trial or appeal level judges. What happens is they rotate. So that you would be today a pre-trial judge, next month or probably after a term of 2 years, you move to the appeal level, then you come back to trial court. That's probably another consideration, so that the term doesn't need to be 10, but and the difference then in the ICC vis-a-vis Kenya would be, the difference is the number of minds, because if a matter is being considered at trial level by 3 judges, when it goes to the appellate level, it is 5 judges. So the difference is the number of minds rather than the seeming. It's not a question of cadre, rather it is the amount, the volume of mind material that is applied to the issue. So instead of the 10 years, probably my thoughts would have been to consider a possibility of having a rotational situation. On budget, I think that would be creating too much class. I know this probably is unpopular, but I think if the Supreme Court was to have a separate budget from the rest of the judiciary, then it would border on a statement saying this is a special court and it's not part of the judiciary. I would rather that they remain part of the judiciary. I hope I have answered your questions.
That's enough. Thank you very much. That's all, CJ. Thank you.
Thank you, Chair. Good afternoon once again.
Good afternoon, Your Honor.
I hope you're not tired. It's been a long day.
I am okay. I'm okay.
Okay, so you are now a member of the bench.
Yes.
And so when we are to evaluate your performance, it has to be evidence-based, because we have a system for measuring that. But unfortunately, I find myself a bit handicapped. I have your report here from DISPOP, which basically captures data on the benches that you have sat in since you were appointed as a judge of the Court of Appeal. I think that's hardly 3 months now.
Yes.
Is it?
Yes.
I think it's about 3 months.
Yes, Commissioner.
Yes, so there isn't much I can engage you on, save to say that you have some non-merit resolutions in the benches that you have sat, and you have had just a few sittings in the Nairobi Civil Appeal Division, the Criminal Division, and also Nyeri Court of Appeal. I heard you mention, though, that you have done one merit resolution?
Yes, so let me explain that. I'm yet to get quite familiar with the terminologies, but this is the scenario in terms of performance. I have served in terms of being on duty, and I think that's fairly routine. I have also sat on single judge matters, and I can say this for a fact that I have no pending single judge matter except the ones that were listed that were coming up today and yesterday. and those ones are scheduled for delivery next week. And so for those ones where I am fully in charge, I have nothing pending except those ones of yesterday and today because I was in the cost list. In respect to the others, as you appreciate, it is collegial. You have to do the draft to circulate, get approvals, and so those ones are still going through the circles. I think my first ones would become due from mid-May.
Okay.
Yes.
Okay, maybe then we can discuss something else.
Yes.
As you probably know, performance measurement has had a long history in this institution. We came from a period when we were violently opposed to the idea of measuring a judge's performance to where we are now, where we have a framework that does that. Now, what I want to ask you is whether there is a legal framework underpinning the need to measure performance in our judiciary. Do we have a legal framework?
Yes, I would say I would refer to the Constitution and say the need for transparency, the need for accountability to the public is such that it should be possible to evaluate and determine whether taxpayers' money designated for judiciary is value for money. And I would anchor my contention on the need for performance on the requirements of the Constitution, that there is need for accountability, financial probity, and and performance. I would also say that the requirement that that would be my argument. I would say performance is anchored in the need to be accountable to the public.
Yes. Okay.
Yes.
Sorry. You're done?
Yes. Yes.
Okay. And there's also the Judicial Service Act, Section 5.
Yes.
That requires us annually through the Chief Justice to give a State of the Judiciary and Administration of Justice report.
Yes.
Which basically, of course, stems from the performance measurement that we do.
Yes.
Now,
I probably just wanted to say this, but I wasn't sure whether I should say it or not. But let me just say it now.
I thought you wanted to say it, yes.
Yes.
You started
I think there is the pending question of quantity versus quality. I think it's something that probably still needs attention. The criteria for determining that the amount, the statistical return on the numbers is not enough, that there is also need to determine the quality of the output. I just wanted to put that additional comment.
Okay. I thought you said you wanted to talk about Section 5 of the JS Act.
I also wanted to say that.
Okay. So the arguments that we had as we were developing this concept in the judiciary was the fear or the concern that this would sort of interfere with the independence of individual judges, because as a judge or as a judicial officer or anyone discharging judicial function, you are supposed to do the same without fear, favor, or any kind of pressure or direction. Now, in your view, are there any safeguards against interference with the independence of judges in the current framework that we have? If you have any, you can mention them. And the second limb of my question, where then is the balance between measuring performance and safeguards, if there are any?
The only argument I would make around that issue is I have no doubt in my mind that there is need to measure performance, and there is need to require the judiciary to demonstrate that they have delivered on it. I have no doubt about that. I think it's the question of how you balance the intricacies around it. And I would think the conversation should be more in saying, are the targets placed on the judges and magistrates too onerous to a point where, in consequence, they look more at making determination even where quality could be sacrificed so that you meet targets. So I think the conversation should be more whether the targets have been balanced in a way that it doesn't place pressure to a point of diminishing the quality of the work done. I would think the conversation would be more there than whether or not there is need for performance. And that's where the balance, I think, needs to be placed.
Okay, that's where the balance, but do we have any safeguards in our laws, maybe statutory,
yes,
or even constitutional,
yes,
to protect or to safeguard the independence of the individual judges and judicial officers vis-a-vis measuring their performance?
Yes, the general proposition that they have judicial independence, I think, is, and the fact that judicial independence right is protected in itself, I think, is the countermeasure to ensure that. And then probably a little more on the judges, also the security of tenure, the process of recruitment, and the budget arrangement for the judiciary. All those, I think, give some level of cushion to protect the judicial officers and the judges.
Okay. Thank you, and I wish you well.
Thank you very much.
Thank you, Honorable Chair. Honorable Judge, I know you've been on that seat for too long, yes, but don't worry, we're about to finish, so my session will not take too long. And now, please address us on the tension between judicial independence and judicial accountability, and tell us how the tension is managed at the level of the Supreme Court, where there is no higher court or where there is no further appeal.
Judicial independence and judicial accountability, I think, is probably the conversation we've just had with the previous interviewer, being the need to arrange so that the judiciary is not such that it is a castle, it is a load unto itself, but is accountable to the public. And so, to my mind, it's a question of just balancing that in the quest to ensure that there is delivery of services, pressure is not placed to a point where the quality of work is diminished. But that independence is necessary and accountability is necessary. And to the extent that your question is, the tension is that my view is that they have to coexist. So somehow they have to find a balance, because both of them are necessary to be to the taxpayers. In terms of the Supreme Court, I think the quality of the work done, I should imagine also that they also have policies on targets of what they are supposed to achieve in terms of timelines and things like that. And I think that still takes care of any concerns that they are not accountable to anybody. But importantly, I think they are accountable in terms of the need to present the state of the judiciary, the need to make presentations to Parliament, the need to justify budgets, and also the public, the access of the public to see their performance is a countermeasure that ensures that the Supreme Court delivers on its mandate reasonably, within time, and to the quality.
Okay. How is the Constitution provided for the independence of the judiciary?
So the independence of the judiciary in the Constitution would include issues like what we are going through, the procedure for recruiting judges, that it is open and public, and the evaluation of the competence is merit-based. There is security of tenure. There is separation of the budget for the judiciary. Those ones come to mind immediately.
Okay, thank you. I'm satisfied. I'm satisfied with those.
Thank you.
The final question from me, I have looked at your choice of referees.
Yes.
You're positively and highly recommended by the referees you provided. And indeed, I can say you know people. So now, given this as a judge of the Supreme Court, if you are to receive a phone call or a message from a senior state officer in regards to a matter that is before the court, how would you go about that situation?
Okay, I would do what the law requires me to do. I would apply the law to the facts, and it doesn't matter what message or call I have received. I would remain faithful to my calling and to my oath of office.
Would you honor that engagement?
No.
Or discussion?
No, I wouldn't.
Okay. Thank you, and I wish you well, Judge.
Thank you too.
Thank you, Honorable Chair, and welcome again, Judge.
Yes.
Yeah, I have two questions for you. Very, very brief. Now, the judiciary is increasingly adapting digital systems such as e-filing, virtual hearings, and automated case management platforms. While these reforms promise efficiency gains, they also raise concerns about digital exclusion, cybersecurity risk, and over-reliance on technology vendors. How should the Supreme Court guide the judiciary in balancing technological modernization with constitutional guarantees of access to justice and data protection, especially for vulnerable and digitally marginalized groups?
Okay, so thank you. I think it's a question of continuously being diligently conscious of the environment we are in, and always looking out to make sure that some segment of the population is not left out. And in that regard, I think the concept contained in the statute is a very useful one, because it endeavors to reach those ones whose access to technology and whose geographical locations may be so far flung off to a point where they might be excluded from the judicial process. So I would think that the Supreme Court, where occasion arises, would also encourage those that kind of enterprise containing the statute, the ADR and the AGS. On the technology, on cybercrime, I think it is also a question of diligence, remaining very vigilant to make sure that the technology deployed are up to date to a point where it doesn't expose the judicial functioning to the risk of cybercrime and hijacking and frustration.
Okay.
Yes.
Now, in circumstances where a constitutionally sound decision is likely to be unpopular and could create or trigger a political backlash, how would you uphold integrity, impartiality, while maintaining the court institutional legitimacy?
Okay, I understand the question, Commissioner, to be what I would do if there is a, what did you...
There's a case before you.
Yes.
And the decision would actually trigger a political backlash. So how would you maintain or even uphold integrity while maintaining the court institutional legitimacy? The decision might likely
I
be
got the question,
unpopular.
Huh? Yes. You could even replace that by saying the LGBTQ case. My view of it is that it just calls on the judges to make sure that they reflect deeply and profoundly on what the issue is, and make sure that the judgment speaks for itself to the extent that anybody who is honest about it looks at it and says in good conscience that indeed the output from the reasoning of the judges is what the law says, and it doesn't matter that it is unpopular. What matters is that the law has been applied, and I can think of a number of cases like the LBTGQ case, the issue of CDF. The judiciary had to deal with adverse view, but I think the quality of the judgment, the way the judgment speaks for itself, speaks well for the judiciary and helps therefore to maintain the integrity of the judiciary and the perpetuation of the judiciary, being faithful to the calling and being diligent in the work.
Okay. Thank you. I wish you all the best.
Thank you very much.
Yes, good afternoon again.
Good afternoon, Vice Chair.
Yes, I know it's quite long, but we're almost through with it.
Thank you.
Now, on global issues, how does globalization affect constitutional law?
Globalization affect?
How does globalization affect constitutional law?
Constitutional law. Yes. Okay. So globalization. Thank you for the question. I think globalization affects the constitution in the sense that even when you have the law, the constitution in place, issues of other jurisprudence come in, and you keep needing to cross-reference it to the constitution. And for instance, the case of BBI stands out very prominently on this, that the constitution is there, it has provided for how it is to be executed, it provides for how it is to be amended. And then an argument is introduced on basic structure. And so you can see immediately the globalization is already integrating with the constitution. And so in answer to your question, yes, the globalization affects the constitution, and the function of the judiciary is to be always on lookout and borrow what is possible and reject what is not in tandem with the constitution. And sometimes see the extent to which they can coexist. That would be my answer, Vice Chair.
How can the judiciary benefit from global networking?
I think it would benefit, first of all, in manpower improvement. The network could be such that knowledge is received and is passed on between the involved parties in the network. I think it would also help in terms of, so that would be first of all personnel capacity. There would be also resource input from partners, and I would think of those two as the important outputs, and also the hybrid of the law that comes then from that kind of integration and relationship.
Thank you. Thank you, Honorable Sija.
Thank you, Chair, Vice Chair.
A microphone, sorry. Thank you very much, Commissioners and Judge. I believe you are very tired by now.
I'm okay, ma'am.
But we are about to complete. Just one clarification from you. When we called out for the applications, there was a list of documents you are supposed to provide. We called for these applications. The advertisement was on 13th January and it was closing on the 17th of February. And we give instructions on how you are to apply and the documents you provide. The list of documents are many. You provided others, except you did not provide a current declaration of income and liabilities as at the making of the application using the prescribed form. What you gave us was a previous declaration you had made for the Court of Appeal, which is dated income for the period 20th January 2025 to 31st December 2025. You are
My lady, do I have your permission to refer to
the
a copy?
Yes, I think that's the one I'm also referring to, the one you filed.
Yes, which page, my lady?
The one I have, show him. Yes, you have seen what I meant, that you are supposed to, when you were making the application, you were supposed to fill in that form for that period when you were applying.
Yes, my lady, I have been shown by the registrar. As you can see, the declaration is dated January 2026, I think. Which is the date it was filled, and the status of the assets between the time I made the previous application and the time I made this application, the assets had not changed, and so that is the answer I have for that. Secondly, my lady, is that my understanding of it is that the world declaration intervals would be after 2 years, and but the declaration I had already made, I had labored under the impression was adequate to that extent. So those two reasons, my lady, that the assets had not changed, and secondly that it was still within the time of my last declaration.
Yes, you see, this was a requirement for the application, for every applicant.
Yes, my lady.
To complete that form, even though you had completed earlier, you should have just completed and said the assets are the same, completed and followed the instructions as per the advertisement.
Yes, my lady. My understanding is that I'm in compliance, although I stand to be corrected. My understanding is that I'm in compliance to the extent to which to the extent to which I've just explained in the answer I've just given, yes. My lady. Let me not belabor the issue.
Very well.
Thank you.
So I think this brings us to the end of the interview this afternoon. Sorry it has been drawn over the time that we had dedicated, but I think the commissioners who are interested in proving your suitability. So this is the opportunity we give you also to engage us.
Thank you, Chair. I just want to say thank you very much for finding me deserving to be shortlisted, for the opportunity to appear before you, and for the courtesy you have extended to me in the questions asked. I want to say thank you very much and wish you well also in the process of doing the evaluation and determining the suitable candidate. Thank you very much, everybody.
Okay.
Yes.
On behalf of the commissioners, we also wish you well, and we wish you success in all your endeavors. We will get in touch with you when we complete the exercise.
Thank you very much.
Yes,
Thank you.
we are now releasing you.
TV, our shared experience.